I'm Steve Crosby, the chair of the Massachusetts Gaming Commission, and I'd like to call to order our 26th public meeting here at Springfield Technical Community College in Springfield. I didn't need any reminding of this, but I did see a CNN show about 9/11 a couple of days ago that brought back to me what is never very far away, which is both the incredible horror of that event and the incredible heroism of that event. And I think it would be appropriate to have just a moment of silence in memory of the folks who died, both at that event, but also subsequent to the event in our effort to try to make good on it. So a moment of silence. Okay. We will start, first of all, just with the quick approval of minutes. There are minutes from first August 22nd. Is that right? August 28th, sorry. And
August 28th and September 4th. Mr.
Right.
Chairman.
I had a couple of quick, under additional hires, it says that the general counsel position, we're leaving the posting open until mid-October. Is that accurate?
Yes.
Okay, that's accurate. And if I'm not mistaken, isn't the woman that the licensed jockey Abad Kabasa, isn't that a woman?
No,
Oh.
that is not.
Okay, all right, never mind that. Anybody else have any?
I have a typo that may have already been corrected, but page 3 of August 28 meetings, the minutes, towards the middle of the page, there's, it refers to HRD, the Human Resource Department.
Yes, I see that.
Training,
And training.
not rain, so that's a,
Right.
There's a couple other typos which
All right.
I find in there. Anything else, Commissioner?
Yeah, there's just a quick typo on the second line in the paragraph right below that, in the report from the Director of Administration, end of the line, it's probably she and not a he.
All right, thank you.
Yep. You want to move?
So I'd move that the minutes of August 28 with those corrections be adopted.
Second?
All in favor?
Aye.
Opposed? The ayes have it. Now the minutes for September 4th, on page 5, at the bottom paragraph.
Right.
It just, weather, not
Yeah.
weather. And on page 6, this one is a little bit substantive. The conversation about the destination gaming facilities, the point that I was trying to make, and I think Commissioner Stebbins and I ended up talking about, and we are now acting on, is not so much promoting tourism as promoting out-of-state and out-of-country guests, really building on the notion of destination as opposed to convenience resorts. I think it needs to be redrafted slightly just to make that point.
All right.
And I think there might have been a couple. Is there anything else? Anybody else thoughts? Move?
All right, so with that correction, I'd move that the minutes of the September 4 meeting be approved.
Second.
All in favor?
Aye.
Opposed? The ayes have it. All right, we get to the meat of our agenda, and we have put the first item on the agenda, the mayor of Springfield and his representatives, Mayor Sarno. Those of you who've watched this know that some issues were raised concerning the consultant selection and the process that the mayor is using. The mayor very, very courteously volunteered to postpone their process until we had a chance to get together and talk with them about some of the issues. We are principally here on a fact-finding mission to try to clarify our understanding of what's going on in these issues, and also make sure that you and your folks understand our issues as well, our perspective as well. We asked the mayor if he wanted to sort of set the stage by walking us through the process, and he accepted. So welcome, Mr. Mayor. Thank you for coming.
Thank you, Mr. Chairman, and to the board members, and to Bruce Stebbins, Mr. Baseball. Glad you came out here in Springfield. I'd like to also thank Chairman Joe Wagner for being here, city council members and members of the community. I will be opening with a statement, and then I will turn it over to my city solicitor, Ed Pakula, and my chief development officer, Kevin Kennedy, and then our consultant from Shefsky and Frolic, attorney Mike Schaller, and attorney Kimberly Kopp. The city's goal is to bring the best possible casino development proposal to the city and its residents and the Commonwealth. We are doing this through an open and transparent process. Prior to releasing our RFP, we met with the City Council, community groups, neighborhood groups, and we continue to meet with such groups to update them on the process and seek their input. Our process includes the hosting of public meetings where residents can furnish comments and deliver their input on the casino proposals. We believe each of the affected constituencies must work together to achieve our goals. The city and the commission each have a role to play in this process and must work cooperatively in this endeavor. We must move forward in the spirit of mutual cooperation, keeping politics out of this process. Political posturing has no place in this process. This opportunity is far too important to let politics play a role in it. Through our RFP process, the city administration will take the lead in selecting one or more developers with whom to negotiate a host agreement, and will negotiate such host agreements, community agreements. The City Council will then have its opportunity to review, consider, and approve or disapprove of the host community agreement. The city voters will have the ultimate say on the host community agreement through their vote on a ballot question that will be presented to them. Finally, the commission will have its opportunity to review and select the casino proposal for Western Massachusetts. This development provides tremendous opportunity for jobs for our Springfield residents and much-needed tax revenue. We look forward to bringing this tremendous opportunity to the city and the Commonwealth, with all constituencies working together cooperatively. At this point in time, I'd like to turn it over to my city solicitor, or actually, I believe Chairman Wagner will be speaking, if I'm correct on it. Then I'll have my city solicitor, Ed Pakula, speak to you, and then we'll entertain questions, and also Kevin Kennedy, my chief development officer, and our consultant to answer any and address any issues or questions that may arise. Thank you again, Chairman Crosby, and to the board. I deeply appreciate you coming to the city of Springfield, and I deeply appreciate Chairman Wagner speaking on behalf of this issue. Thank you.
Mayor, as you go, I'll speak for myself, but I'm sure I'm speaking for the others as well. I have absolutely no doubt that you are looking to make the best deal for Springfield. I don't doubt that for 1 second, and I don't doubt your integrity in doing that. Reasonable people can differ about things, and we may or may not differ, I don't know. But there's no question in my mind about what you're trying to do for the people of Springfield, and I appreciate that.
Thank you, Mr. Chairman.
We had a special...
If you prefer to take the development officials, that's fine. I'll leave that to your discretion.
Well, Chairman Wagner, you're a distinguished guest. I think we'd like to have your 2 cents worth. No, it's more than 2 cents. Chairman Joe Wagner, the House Chairman of the Joint Committee on Economic Development and Technology, his committee, he was one of the architects of this legislation, and his committee is one of the committees to which we report much of our work. Thank you for coming, Mr. Chairman.
Mr. Chairman, thank you very much, and I will be brief, and I did understand the political code for 2 cents worth. It will be brief. But I want to just take an opportunity in just a moment to welcome all of you back to Western Massachusetts and to thank you for your efforts to this point, having in your hands an undertaking as mandated by the legislature to bring online a new industry, which we hope, done correctly, will bring thousands of new permanent jobs across this Commonwealth and hundreds of millions of dollars in new state revenues. And I have appreciated the public comments, Mr. Chairman, of you and other commission members for your understanding of and respect of the legislative intent, even though much of it is subject to interpretation by the commission, and that in fact was how it was intended to be. We couldn't very well give you the charge and then try and micromanage how it is the commission went about your business. So I for one, have been pleased with the way in which this rollout has happened. I know that we would all like to see it evolve quickly and to happen yesterday, if you will, but I think we understand the practical realities facing everyone. It took the legislature many, many years of conversations and deliberations and debates to finally enact something into law, so that it would take the commission some period of time to try and pull things together and move it forward in the best and most productive way is something that I understand and I'm appreciative of. I sit here today wearing several hats. Obviously, I chair I'm the House Chairman of the Joint Committee on Economic Development and Emerging Technologies. My committee had oversight of the matter of expanded gaming before it became law. But I also represent the people of Chicopee, who, in the case of a consideration of a resort casino here in western Massachusetts, may or may not be a surrounding community. And my city, in fact, may be contemplated as a host community going forward. I wouldn't know that at this particular point in time, although I know it has been discussed. So I wear my economic development hat, the chairman's hat. I wear a hat which has me representing the people of Chicopee who are impacted by this. I wear the hat of a Chicopee resident and also as the father of 2 young children. And I understand all of the issues, particularly the quality of life issues that go to what it is we are trying to do. So in that respect, I appreciate your call from minute one, never mind day one, for a process that would be transparent, open, above board, free of politics, and I think that you have met the standard that you have outlined as this thing has evolved to this point. I want to talk about, particularly as it relates to your fact-finding mission, Mr. Chairman, and to the Commission, I want to talk about some of what we hope to accomplish legislatively in fashioning the matter you are now charged with carrying forward. We looked at what other states did in terms of best practices. We looked at what happened in other states with respect to the potential for pitfalls and difficult circumstances that we might not like to deal with, but that we understand as a Commonwealth we will have to deal with. We tried to protect, in fashioning this legislation, other sectors of industry, even as we know and understand that there will be impacts on existing businesses as we bring a new industry online, and not all of those impacts good impacts. We wanted to protect lottery and the billion-dollar industry that we have here, and we wrote that into the legislation and charged you and communities in terms of host agreements and potential developers with looking at those things as well. We gave a good deal of consideration to process and process-related issues, and we talked openly about transparency. I don't think that we contemplated legislatively what we are watching evolve here in Springfield with respect to there being any number of operators. I think we all envision that in any community, the community would partner with a developer and that they would move forward a proposal. Springfield's circumstance, at least to this point in time, is certainly unique, with 2 developers having indicated an interest in Springfield and perhaps more who will follow. I do think that local officials in Springfield, I want to be careful about how I make this point. I agree with you that I think that local officials have tried to be transparent. And I understand that this is new for everyone. Just as you are trying to get the entity of the Gaming Commission online and getting it to a point where you think it needs to be, I know that local officials are in fact trying to do the same thing. I watch with great interest, wearing many hats, because I want to see a successful effort here in western Massachusetts, no matter where a facility would be located. And what I have seen, and I am not pointing fingers at developers, but I think I get politics pretty well. And the politics I see being played is more often than not being played by those people who would be casino interests and who realize there is one ticket potentially to be drawn here in western Massachusetts, and everyone wants to impact that process from arm's length. So I have no doubt that you understand all of that, but sometimes the clutter gets in the way, and I don't want that to impact, from the hats I wear and from the seat in which I sit and view this, I don't want that to impact what I know will be a productive process for the Western region as this evolves and unfolds over some period of time. And again, I pledge my support to you and to all local officials to try and be helpful in terms of providing any legislative guidance, particularly as it may relate to any changes which may be necessary as we go forward. We don't contemplate necessarily some things in the short term, but you may as you move forward, Mr. Chairman, and I know that there are issues relating to the racing industry, you may be seeking some amendment to the legislation going forward that we will have to consider. And so I appreciate, again, your being here. I appreciate your comments to the mayor. I know that in addition to Springfield, there are other communities in Western Mass interested. I know that Palmer is one of those communities, and I just want for the dialogue to be productive, and I sense it has been, and with that said, my remarks are concluded, and I'll let you get on with the business before you. I'm going to sit and try and do some fact-finding as well here today. So thank you all.
Thank you, Mr. Chairman.
Thank you.
Just one point. I understand, I think, your statement about knowing politics when you see it, and I do want to make clear that the issues that we are interested in talking about arise from our own judgments. You know, this is not about responding to anybody's complaints or anything. It's totally independent, and I think actually were raised by us before there was any squawking in the media. So I totally agree with you. We will do everything in our power to try to keep this as non-political in that sense as possible. But we are responding here to concerns that are in our own judgments.
And I understand that, and I didn't mean to suggest
Okay.
that you were doing anything other than that. I do think, as I observe this from where I sit, that everyone involved officially has, the commission, local officials in Springfield, and other local officials who have made comment. It's not just Springfield, but in particular Springfield, and because of some of the issues recently raised, I really think that everyone is stepping forward with the idea that the process, whatever the process will be, and it is unique if we are talking about Springfield, we had not envisioned this, but I do think everyone has tried to put forward their best foot. I think things have been transparent. I think that people have tried to offer things up in the right way, and where there would be disagreement, I think your words, where there would be disagreement, that disagreement can be the subject of dialogue, discussion, ultimately resolution, and as you know, and you've been around it, I'm in a business where we disagree often, myself and my colleagues, but civilly.
Right.
And
Right,
so,
thank you.
thank you so much.
Thank you very much. Gentlemen, do you want to introduce yourselves?
Certainly. Edward Pakula, I'm city solicitor for the city of Springfield.
My name's Kevin Kennedy. I'm the Chief Development Officer for Springfield.
Thank you for coming. Mr.
glad to
Pakula,
be
nice
here.
to put a face to your voice. Do you want to start out with some opening observations?
Certainly, if I may. I think the Massachusetts Gaming Act provides the commission with the authority to award a very valuable right, a regional monopoly, to run the only casino in western Massachusetts. And under the act, the city government's participation in this process is negotiating the best host community agreements. Commission will be choosing the licensee, but not until the executive branch of government, under the City of Springfield's Plan A charter, strong mayor form of government, has negotiated one or more agreements with developers. The City Council has approved the host community agreement, and an election of voters has approved the agreement. The gaming industry is highly specialized, and where the casino operators all have very high-powered consultants, and in order to negotiate the best agreement or agreements possible with these companies, the city needs to retain the same high-powered consultants that the casino operators utilize. While we are rightfully concerned about the appearance of any conflict of interest, state law provides for the filing of a disclosure under Chapter 268A, Section 23B3, to dispel any appearance. And such a filing has been made in this situation by the consultants. I have a copy for you today, and I will include that with a copy of my remarks for the record. The city issued an RFP and followed a process similar to the Commonwealth when the Gaming Commission sought qualified experts to obtain casino advisory services, and the city drew on the same pool of experts as did the Commission. And a review of the pool of qualified consultants shows they have all represented many casino operators throughout the country. During the city's RFP process to retain a consultant, Shefsky and Froelich disclosed to us that it represented MGM in the state of Illinois at the time it submitted its response to the RFP. At the interview, as the potential for Penn National competing for a gaming license came to our attention, it was also disclosed the consultant has represented and represents that operator. In addition, the consultant has represented Hard Rock Cafe in the past. However, the consultant is not representing any gaming operator interests in Massachusetts and has agreed to forego any such representation until the representation of the city of Springfield has been completed. Our consultants have advised us that they have reviewed the applicable legal and ethical regulations concerning the matter in the state of Illinois and in the Commonwealth, and have concluded that no conflict of interest exists which would prevent their engagement by the city. To confirm that all conflict of interest provisions are complied with, our consultants are able to seek an opinion from the State Ethics Commission, which includes all the pertinent background information so that the formal opinion can be issued outlining any limitations in more detail. The city's not a party which would request that opinion. Our consultants have done that on their own. Such opinions are confidential and would not be subject to public disclosure, of course, unless agreed to by the consultant. The lawyers working on behalf of the operators in Illinois are excluded from working under the scope of the City of Springfield contract. In addition, the lawyers working for the City of Springfield are walled off from working on matters in Illinois. Indeed, our consulting team of Mr. Froelich and Schaller and Ms. Kopp have informed the city that they have not performed any services for the casino companies who have announced an interest in locating the city in at least several years. City consultants of this nature are considered special municipal employees under the State Conflict of Interest Law, Chapter 268A. As special municipal employees under the state statute, the prohibitions of accepting other employment are less restricted than in other situations. In the city's contract with the consultant and the city specifically agreed that the attorneys from the law firm and team providing services are permitted to render legal services to and be employed by other governmental bodies, private persons, and firms, so long as such employment does not interfere with or conflict in any way with the work for the City of Springfield, such that those employees are considered special municipal employees as defined by state law. In this situation, the Commission should be aware that the city is seeking payments of the consultant's costs from developers pursuant to provisions of the Gaming Act. The city's consultants have recommended a process that has been utilized successfully in Michigan, and this process is designed to develop a proper competitive process to cover the city's expenses pursuant to the statutory provisions, And specifically, Mass General Law, Chapter 23K, Section 4, Clause 7, and Section 9, Clause 13, provides that a municipality is authorized by the Act to seek funding for professional services to examine or evaluate a cost, benefit, or other impact, and casino operators may be required to provide and pay for advisory services and technical assistance as may be necessary for the reasonable costs related to legal, financial, and other professional services that are required to negotiate for the negotiation and execution of host and surrounding community agreements as provided in Section 15 of the Act, and to require that such costs be paid for by the applicant for a gaming license with the Commission. The city has asked the consultant to appear before you today to discuss the RFP process, which has been outlined so far, and which remains being drafted, particularly in light of our delay in issuing the RFP. And we thank you for your assistance and cooperation.
Sounds like you're taking this in two bites. One is to talk about the consultant selection process, and then also about your RFQP process as well, right?
Yes.
Which I think makes sense. I have a couple of just factual questions. You may have said this, I'm not sure I did. Did the city council have, did they approve this in any way, or were they involved in, are they involved in any way? Were they involved in any way?
In the RFP of selecting
In the
consultant?
selection of the consultant, yeah.
That is not SOP for the city. In the city of Springfield, where we have Plan A charter, the mayor carries out all of the executive functions. The city council is the legislative branch. So the gaming legislation recognizes as its definition the governing body for purposes of the statute is the mayor and the city council. But the local aspects of this, which are different for Palmer or Chicopee or Springfield or any other local community, is that Springfield has a Plan A charter. And under its Plan A charter, where the mayor holds the executive authority, the legislative body, the city council, does not. And it's standard for any economic development process that it is the mayor that is responsible for administering and bringing those agreements to a negotiated state, and then once executed, bringing them to the council for approval. That is, different than they may do it for Board of Selectmen or town manager or other situations.
But was it then approved by the council? Is that what you said?
No, the only approval we needed for a consultant was the appropriation of the funds, which was included in the budget. But all contracts for employment are made by the mayor.
I guess
subject to appropriation, not approval by the city council. No contracts in Springfield for employment other than some
Right.
specially designated in the charter.
I understand
go
that.
before the city council.
I understand that. But when the budget item was approved, which I think I understood you to say, the budget item was approved by the city council. Did the city council know about the representation of MGM and Penn National?
My recollection is the budget process preceded the selection of a consultant.
Okay.
As
And
a city-
just one other quick thing. When was the request for an opinion made to the Ethics Commission?
Friday, September 4th.
Okay,
I'm sorry, August 31st.
August 31st. Okay.
So has the city engaged the services already of Shevsky and Froelich?
Yes.
Have they signed a contract?
Yes.
Are there other questions?
I have a couple of questions about that process. Back to the city council, sir. So when were they made aware of this issue where the law firm selected presently represents two of the potential bidders here in Springfield? They represent them in other states. When were they made aware of that?
Being made aware of it on a formal basis is not something that typically happens other than through the normal process. It was disclosed in an RFP. That RFP was a public record, and anyone who wanted to see that RFP knew that. We looked at that as a favorable thing for the city in that we knew that we were going to be getting that same sort of firepower that the casino operators had.
I'm sorry, you looked at what as a favorable?
The fact
Please.
that they had experience representing casino operators.
The same two casino operators that are bidding here in the city, you looked at that as providing firepower?
Certainly. If you're negotiating and you're going to be dealing with tactics and strategies from the industry, you're going to want to know what's coming, and you're going to want our consultants so that we have that same sort of leverage.
How do you respond to another casino potential bidder who is claiming that they see a conflict? How would you respond to that potential bidder?
I would say that the conflict of interest laws in the state are set forth in Chapter 268A. The standards there are objective standards. They're not based on any sort of a arbitrary process, and we need those sort of objective criteria when we review these. That matter is pending before the State Ethics Commission to be decided by them. We have reviewed this. Our consultants have reviewed it. We're confident that there is no conflict of interest under Chapter 268A. We're confident that we've filed the proper disclosures pursuant to Section 23B3. And again, that would be the type of disclosure that would be made at the time of an RFP. The plan was to attach the disclosure to the RFP so that anyone would see that at the time of bidding. That would be the proper time to disclose it to the world.
My question is, you asked for, or actually the law firm asked for an opinion from the State Ethics Commission after this became an issue, not before. Did you or the law firm not see that as an appropriate action before you hired them?
No, I think that the issue is, and again, in the nature of being city solicitor, I'm commonly called upon to review conflict of interest opinions. And we certainly had reviewed this situation at the time of contracting with the consultant. And as I said, I am of the opinion there is no violation of Chapter 268A. And then what needs to be done is to dispel any sort of appearance of a conflict by the filing of a form pursuant to Section 23B3 of the Act.
Sir, do you have any idea when the Ethics Commission will rule on this matter?
I do not. I think the consultant maybe has had those conversations. Again, as I said, the person who has a potential conflict is the party that has the right to the opinion. So, as I said, our consultants can maybe have some more information on that.
Last question, sir. If the state ethics has a different opinion than one that you believe is so, do you have any idea how you'll proceed?
Well, if that's a situation that occurs, and I don't think that will happen, but obviously that's a possibility, and we'll review it and we'll see. Typically, when these opinions come out, they talk about restrictions and limitations that have to be put in place. I don't see this coming out as saying somehow this is a prohibited transaction or anything of that nature. But we will review whatever opinion that is provided to us and deal with it appropriately.
You made mention that this is not a public record. This ethics opinion, does the law firm and the city intend to make this public?
It would not be the city's call. That would be something for the consultant.
The consultant works for you, sir, so you wouldn't ask them to do that?
Certainly, we would hope that they would, but as I said, we have to respect the confidentiality provisions in 268A. So in that respect, we have cooperated with the State Ethics Commission. Can we get you any documents? Is there anything we can help you to do? Can we provide you any information? That would be our role, but it would be up to the consultant to ask for and the commission to rule on.
Thank you.
Before I ask a question, let me apologize for keeping you waiting today. Mr. Mayor, Mr. Chairman, I know your time is valuable, and I apologize for being late. I perhaps feel spiritually closer to Springfield than geography permits, but I do apologize. You said the disclosure's been filed. And can we have that disclosure?
Yes, that's with the
Today?
city clerk's office, but I do have a copy with you, which I can submit with my remarks.
When was
Thank
that,
you very much.
when was that filed?
They FedExed it to my office on August 31st, and I believe it was received on the 4th, and I believe that's when I sent it down to the city clerk's office.
Other
That's it.
questions?
That was my only question.
This may turn out to be a place where there are reasonable people can differ. I do want to make a couple of points. First of all, we talked to Shefsky and Freilich. You know, they are an outstanding firm. There's no issue about that. Secondly, as you know, there are, to tell you the way I'm thinking about this, there are 3 levels that the Ethics Commission will advise about. The first is whether actually is in fact a legitimate conflict of interest, as you said. Secondly is whether there is an appearance of a conflict of interest. But the Ethics Commission will go on, either orally or in writing, and sometimes talk about situations which require an even greater sensitivity than the letter of the law to issues of conflicts and appearances and so forth. In an opinion which was written for us, I'll just quote a sentence that the Ethics Commission wrote. Of course, there may be situations where it will be better to go beyond what the law requires and abstain. That's from them, talks about a sensitivity to the issue of appearance. What I think is in our minds is that there is this extraordinary sensitivity to this particular issue. And we are trying as hard as we can to hold ourselves to an extraordinarily high standard. We will err, we all do. We are trying to we will be writing ethics rules. We are mandated by law to write ethics rules which are above and beyond those which are already in place. And all of us, to make sure that none of us are besmirched by the actions of one another, all of us need to go out of our way to be extraordinarily sensitive to what could possibly be construed as the opportunity for or the potential for something other than total objectivity and the merits in this process. I know I've said this to you before. I want to be candid and say publicly what I've said privately. So I think I do want to say one other thing, that we are mandated, you know, we have as part of our mission statement, as you know, and you have spoken to, a mission to try to establish the principle of being fair and transparent and participatory, as you are as well. But Section 1 also gives us, in our purposes, quote, to ensure public confidence in the integrity of the gaming licensing process, to ensure public confidence in the integrity of the gaming licensing process. And it's under that purpose that we are thinking about this and trying to reason back and forth with you as to what's the appropriate course of action. Does anybody else?
Well, I'd just like to say that while I agree with the sentiments that we need, everybody agrees with the sentiments, I think, that we need to be as transparent and to use your phrase, Mr. Chairman, squeaky clean in all aspects of this process as we possibly can be. The process is itself an important element of what we're doing. We've got statutes that deal with conflicts of interest. We've got an agency that is charged with enforcing those statutes. We have an agency that has demonstrated in the past and continues to demonstrate that it is not a toothless tiger. We have the capacity.
That is the Ethics Commission.
The Ethics Commission. Clearly an agency that has been vigorous in enforcing the ethics laws throughout the recent past, at least. We have civil and criminal penalties in the ethics statute for violating the ethics rules. There is a provision that says that if the ethics laws are violated, that the consequence of the decisions made as a result of the violations can be undone. And then we have the power to, as you rightly point out, shape and patrol the field on which we're playing, the entire gaming operation. But the question is, how do we shape that? And it seems to me that we all agree that a fair way to shape it is by announcing rules and standards by which the conduct of others must be measured. And we have a lot of opportunity to do that. We're in the process now of creating and will soon promulgate an enhanced ethics code. It is perfectly within our purview to say that everybody involved in the process must adhere to certain provisions of that, and to draft provisions of that in mind, with that objective in mind. So we have an opportunity to do the kind of patrolling that I think we all feel is necessary to ensure the outcome on which we all agree. The question is, for me at least, speaking as one commissioner, and I'm sure we share this, the process that we use to make the commitment to a fair process. And I know that we're committed to a transparent and fair process for promulgating the rules of the game so that everybody knows the standards by which they're bound.
If I may, I would echo the comments of Commissioner McHugh in that we do have state agencies to deal with these issues. We do have a legislature who has written laws dealing with these issues. We have regulations dealing with these issues. So when the when you say, well, but there's another test here, but it's not articulated in any sort of process that has been set forth, we potentially cross the line of having any process and go contrary to those purposes that we set it forth in the first place. If those types of decisions have been delegated to a state agency who has handled that type of work appropriately and that we all have confidence in, before we take any further steps, we need to see what that agency's ruling will be.
Well, that was certainly our conclusion on Tuesday. We had hoped that maybe we would have that decision. We don't, I gather. So we may, at the end of this conversation, at the end of our meeting, talk further amongst ourselves about whether we want to do anything more. I think at this stage of the game, we've said all there is to say, and we appreciate all of you speaking to the issue. And I reiterate that I don't doubt the good faith of the parties here. We're talking about a very subtle issue here in nuance and appearance only. Do you want to move on to the second item?
I actually have a question.
I'm sorry.
I have a process question that you may get into, Mr. Kennedy, but it's also relative to the ethics question. Is the city currently planning on issuing the RFR that was planning to issue last September the 5th?
I mean, you can talk to the mayor and the CDO about that, but as far as I'm concerned, until we have more answers from here and elsewhere, I think it's on hold.
Okay.
Mr. Kennedy?
Thank you, Commissioners. Maybe let me preface my remarks by maybe answering one of your questions, Commissioner McHugh. Commissioner Cameron. If your question was, if the Ethics Commission ruling came back on a negative basis, what would we do? I think that's what I heard you say. My friend, the city solicitor, is a very good lawyer and protects our interests to a great deal, and I appreciate it very much. From a practical point of view, I can assure you I will be recommending to the mayor that we take the necessary steps to correct it. So I'll let that be said for itself. I guess I'm the one that's guilty of the situation that we're in here, aside from the ethics part, but the fact that we have 4 or more competitors here, I guess I take the guilt and I'll take the responsibility happily. I recommended to the mayor back some 8 or 9 months ago, when Ameristar was our only potential operator, that we not join Ameristar as a partner, that we try to embark on a strategy that will result in more competitors and more operators and provide us with a greater choice. I thought that was what the legislature was interested in, and I thought that's what you as a commission would be interested in. Today I can happily say that we definitely have 4. There is another one, I think, that is in town looking about, and goodness knows, maybe there are more. We would happily take them on in our situation, and the question then becomes, okay, now that you've got a number of operators, because nobody else has written the book here in Massachusetts. What do you do about it, and how do you go about a process that can result in maximum benefits for both the locals, us, you as the representing the state of Massachusetts and the whole region. So what we've embarked upon is the process that I think we've sent you a copy of some of our information. And let me try to address some of the situations I think that are in front of us. First of all, on the issue of consultants and the job that consultants perform. I've been in this business for the better part of 30 years, and I've dealt with consultants for the better part of 30 years. And we've received an awful lot of good advice from previous ones that I've worked with, and I can tell you right now that Shefsky and Freilich has given us good advice to this point. But I will also stress to you the fact that I'm using the word advice. Shefsky and Freilich, as is any other consultant, is not the decision maker. The decision maker will ultimately be the mayor and the city council, and I would think that myself and Eddie, our solicitor, and others will have some influence in the process, but I can assure you Shefsky and Freilich are not the decision makers in this process. We fully recognize the value of this project, especially from an economic development point of view. This, while it is a gaming operation, we are going to treat it as an economic development project. And that's where the real value lies to the city, the region, and Massachusetts. We intend to maximize the benefits for all those connected. We also intend to control the development of this facility within the city limits if the Gaming Commission grants us a license. We believe the best way to maximize the benefits is to create that open, transparent process that the mayor talked about, that the solicitor talked about, and that you're fully aware of. We intend to work with our surrounding communities so that we can ensure benefits for all. It would be incorrect to assume that all the jobs and vendor benefits from this potential $1 billion project will only remain within the boundaries of Springfield. As we do with Union Station or Westover Air Reserve Base in Chicopee or the Big E in West Springfield, we will communicate with each other and cooperate with each other to the fullest extent possible. We are anticipating that we will be negotiating a host community agreement on the basis of public safety, education, tourism, arts and culture, economic development, and we will also consider a gambling mitigation effort. Whether the casino license is granted to Springfield or Palmer, we intend to work with and use our voting power on the Pioneer Valley Transit Authority to create a fully integrated transportation system in conjunction with the casino. In conclusion, let me assure you and the citizens of Springfield and the region that we will maintain our focus on creating the best world-class casino possible. We will not be distracted by the noise that goes with the process. Working with you, we will attain the best result possible for Massachusetts. Thank you, and I'm ready to answer any of your questions.
Thank you, Mr. Kennedy. Commissioners?
Yeah, I have a couple of questions. Has the city in the past or recently studied or commissioned studies to figure out, regardless of where of an operator, to figure out where in the city might a project of this magnitude have the best impact?
Well, we know that Ameristar is in the eastern portion of our...
Forget about operators. Just conceptually, anywhere in the city, is there a place that would be most beneficial, that would increase the desirable traffic and would mitigate the undesirable traffic? Just to say on one aspect, on traffic.
No. I think the simple answer is no. We don't want to prejudge these. With this project, as we look at the potential operators that are there, there are pros and cons with all of them. It would be very difficult to pick out the ideal location because, quite frankly, I don't think any one of the four are going to be the ideal location. What we need to do is to pick out the best location. So it's kind of, I can't answer you any more directly than that.
I'm curious about the criteria that you will use that you have drafted in the RFR, I guess, that is still being drafted. Could you explain a little bit more what that criteria is going to be for selecting the rights to negotiate with one or more?
Well, I'd have to consult all the detail, and I don't think I can do that in this situation, but I can tell you generally that what we're looking for is a economic development proposal that is going to satisfy and fulfill our greatest needs. And by that, on the face of it, every one of the proposals is going to satisfy the job requirements because it's going to create 3,000 construction jobs. It's going to create 2,500 continuing jobs. It's going to provide us with a great deal of tax revenue. It's going to provide a great deal of benefits on the basis of a host community agreement, and it goes on and on and on. And we should also mention that each one of the operators has a philanthropic side, so that besides the benefits that we're talking about on the host community side, I think everybody's going to benefit a great deal more. We are also interested from our point of view of, and there's been a great deal of discussion here with the University of Massachusetts locating here to Springfield, and there will be significant needs by all casino operators in the so-called workforce development world. And so there may be some ability to do some partnerships there, and we're going to investigate all those. The criteria that you're talking about, what kind of a corporate citizen are they going to be?
No, I'm sorry. Go ahead. I interrupted.
Okay, I'm just going to talk about the type of corporate citizen we judge them to be, the financial stability of the company that we can see, and then we would defer to you further on that because your financial investigation is going to be far more exhaustive than ours. So we would defer to you in terms of that. Thirdly, I think that we're also looking at an area where can it do us the most good, where we have the most need in Springfield. One of the areas that easily comes to mind is the south end of Springfield where a tornado went through on June 1st of 2009. We have significant needs there. We also need to make judgments on what is in our infrastructure in each one of the 4 locations, because that will require a great deal of effort on all the casino operators because there are many, many utility-related functions that go below grade, especially in the downtown. We anticipate contracting out for wastewater study, water study, transportation studies, all those kinds of things, so that we make sure that we maximize what we're doing. So I'm being a little bit evasive for it, not so much evasive, but I have to give you a general answer until we actually see the specifics of each one of the proposals, and then we will try to judge them on a specific basis.
And I appreciate that. I guess I'm interested in the criteria for selection that you will apply in terms of choosing to negotiate with, choosing to select one or more.
I'll tell you what, if I could let my friend the solicitor answer,
Yeah.
there are some specific criteria.
Yes. I believe, as Mr. Kennedy indicated, public safety and the jobs and the education, those are the general areas of criteria that there will be. But this is planned to be a 2-phased, and our consultants will talk more about this. But phase 1 is really to who is out there and who is really going to be interested in doing this. It is not at that point that there'll be any selection being made other than that, who is willing to help us cover the costs so that, because that is a big issue of how to pay for these consultants, how to do some of the studies that you're talking about. Those are the types of things we're looking at in phase 1. Phase 2 is where there'll be a selection criteria, and that, as I said, nothing's carved in stone in that other than what's in the statute. And at this part, we've looked at the same criteria that the statute has to try to match up.
Let me try to
that
answer.
criteria, I'm sorry, that criteria, I read that statute to be one that the commission will apply, not necessarily one that the city will apply. But I'm interested in the process that you are mentioning, and let's go back to phase 1 for a minute. Have you considered that requiring the operators that are out there to submit their fee, the application fee to the commission?
Yes.
Is that a requirement in the RFR as you have drafted it? Because we currently only have one operator that has submitted that fee.
Yeah, go ahead.
Okay. Actually, we have discussed putting in phase 2 that anyone who's going to be submitting is going to have to also have been submitted their $400,000 to the commission. What we're looking to do is try to make a process that's complementary to what you do. So, for example, we understand your vetting process, is very detailed. We don't have the resources to do that, but we don't want to make anyone do anything they don't have to do for you. So we want to, the information that they would be providing would be some of the same materials they would provide to you, and so that anything they did put together for us would be anticipation of putting it together for you. So then when we get to phase 2, as you indicated, all right, if you're really going to be serious, what we've considered saying is you are required, as part of phase 2, to pay your application fee to the state so that that process will get going and the resources will be available to the commission to start on their process, so that hopefully when we get to the finish line, there'll be some coordination that either the commission doesn't have to wait long for the city to conduct its vote and vetting, and really those issues of local interest, not legal, but economic development-wise, that you mentioned, what's best for the city. But process-wise, we want to see how we can dovetail things together. And that's where our consultants have used this process in other states. And, when we went through the RFP process and we recognized we had this unique issue, we asked all of the consultants, how do we deal with this? And to the T, they all suggested you need to do an RFP process to narrow it down. You need to narrow it down for yourselves. You need to narrow it down for the commission. Otherwise, there's going to be a long, excessive, expensive process. No one had a really good explanation of how that would work other than the consultants we selected who said, let me tell you how we did it in Michigan. And they explained they followed a 2-tiered process, step 1, step 2. So now we had some flesh on the bones. We had a process that had been tried elsewhere. It had worked successfully, and that was one of the most appealing parts of why this consultant was selected. They had been there and done that, and we were searching, how are we going to deal with this? And that was one of the most difficult things that we saw going back to April when we were looking for solutions.
Let me, if I don't insult you by reading from something, but I have the specific criteria that you refer to. If you would like me to read it, I can to you. We're expecting that each one of the operators will propose a project that will, A, make a significant and lasting contribution to the city and the Commonwealth, increasing sustainable economic benefits from tourism and conventions. 2, be a catalyst for additional economic development in the city. 3, create good-paying jobs and new employment opportunities for city residents. 4, support utilization and participation of local and small business suppliers and vendors, including minority business enterprises, women business enterprises, and veteran business enterprises. 5, support utilization of existing city entertainment venues. 6, mitigate any adverse impacts of the project on the city and the surrounding communities. 7, provide additional revenue for the city, and it's expected the project will be completely unique, providing a standard of service and excellence that will be known throughout the Northeast region of the United States, if that answers your question.
Yeah, and I guess, let me press if I may, how, if I'm an operator, do I know that I have exceeded the expectations of the city in any one of those criteria? And the point I'm trying to make is to the extent that it's most specific and can be assigned, and the city can assign a particular score, let's say. I don't know if this is what you're thinking. Somebody can really, hopefully, try to think outside the box and be creative with their proposal.
Well,
but some of the criteria that you outlined, Mr. Kennedy, seems a little broad, and I know it's difficult. It's inherently difficult to score them one against each other. But you do articulate that you will be narrowing down in what you're setting out to do. And in my opinion, to the extent that you can narrow that, be as specific as possible when it comes to telling the public, the operators, where your priorities may be in terms of what you want to see out of these proposals will be to everybody's benefit.
Well, these are the general categories, you're correct. We're going to have to make judgments on that. And like a construction process known as CM at risk, I intend or expect that when we get the proposals in, we will be going back to them and say, you know, you might want to do a little bit better in XYZ category because maybe this other operator proposed something else. I mean, we are going to drive a process here that is going to result in the best deal possible for not only us, but in the best deal possible for the Commonwealth. So we're going to push them. I will freely admit to that.
Can I add another question?
Sure.
Mr. Kennedy, I'm going to refer to your letter to Chairman Crosby
Uh-huh.
outlining the process. And I just heard what you both said about wanting to complement our process. My concern with that, or my question with that, is that your process is complete before we even, our deadline for accepting applications. And my question is this, and I'm going to refer to your letter, and that this is on page 3, the second paragraph, where you say, the city believes that by conducting its selection process on its proposed timetable, the city will be relieving the commission of the burden of conducting these suitability investigations. So what you're saying is, although you say, for example, the financial investigation, which you have listed as 5 days, I'll be honest with you, I'm not familiar with any kind of a financial investigation that can be completed in 5 days. If you're going to relieve us of the burden, I think what I'm hearing there is that some of these entities may not even apply to us. And I have a question about that. For example, if you select someone who ends up not coming through our suitability process in a favorable manner, and later on in the letter, it talks about, well, then you'll know how to go back and renegotiate a host agreement with one of the other entities. What if one of those entities hadn't even applied to us?
Well, I think one of the answers to you, without being specific, is that we can conjure up any number of speculative situations that may or may not happen and come up with a question that we can't answer. But secondly, I will say to you that I think I specify that I refer to the financial review on a very high level, so we're not proposing that we're doing the same type of review that you would do. We know that. Secondly, or thirdly, I think that our process, we can do the process within the time constraints that we've laid out. I think it's practical. It's definitely doable. I think one of our goals that we want to have done here is we want to have an operator that can go forth and apply for one of your licenses as soon as you're ready to ask for that application. And as I understand the law, we have to have our process completed before that particular operator can apply for a license.
Question about why did you consider, I'm not sure about your time frame here. Did you consider waiting till we complete the suitability investigations, which then gives you a very thorough idea of financial suitability? You mentioned in the letter that, well, they all have licenses in other jurisdictions, but, the suitability investigations do change from year to year. For example, there's one casino operator that has multiple licenses that ran into significant suitability issues and withdrew their application in one jurisdiction. There's another that received a conditional license because their financial circumstances have changed dramatically. And there's a third that was in the licensing process and completely lost their financial backing and had to withdraw from the process at the very late stages. So I think your comments about, well, they all are licensed in other jurisdictions, I'm just concerned that
Well, again, I don't think we can cover every contingencies, but we do plan on adjusting where we need to adjust as we go along. We do have a reasonable expectation that the operators that we have before us are probably going to be vetted by you successfully. Although the possibility does exist that that may not be true, and we may have to adjust. And if we have to adjust, we will adjust.
Can I just follow
I
up?
should also add, your process, the timing part of it has changed from time to time over the last 6 months or so, so it's been a little bit difficult from our end of it to actually apply. So I don't mean that as a criticism. I understand you've had to make some adjustments yourselves.
Could I just follow-
If I may, the operators are very pleased that there's been a process put in place on the local level. I have to speak with a hat, wearing a hat of a mayor now. We're in a unique situation. Many a times the mayor, whether it's Boston or other place, has a drive and agenda for economic development to retain companies or bring companies into their jurisdiction. Our strategy was to maximize the competition in order to drive the most aggressive deal for the taxpayers, the residents, and the business community of the city of Springfield. My job, our job is not here to cater to any kind of casino operators. Our job is here to drive that competition. And I think the comment I used before on some of the RFPs we're looking to do, smoke out who are the contenders and who are the pretenders as we move forward. The final say, obviously, and that's democracy. The voters will have final say, and obviously the Gaming Commission will have final say over it. We're very hopeful to have something in the city of Springfield, but it puts us in a unique perspective, the competition. And I think that's what the letter of the law, the legislature saw fit about maximizing competition. We have not done, as other municipalities had said, it's going here, this is the one that's coming in, period. So we're trying to be open about the competition to drive the best deal, not only for the city of Springfield, Mr. Chairman, but for the Commonwealth of Massachusetts. And it's important, as you see with the casino operators, they have firepower. They have consultants, attorneys, et cetera. Now, we might, we're east of 128 and 495 and west, but east, all the action's east there, and they might not think, geez, we can get over on us. We're trying to do our due diligence on this and continue to work with the Gaming Commission, but this is very, very unique. We're driving the agenda. It's not them driving the agenda to us to make sure we maximize that competition. And I think for any mayor, that's very, very welcome in this tough economic development situation. You look at this benefit here to the city of Springfield and the surrounding areas. Just on property tax revenue, conservatively, $15 to $20 million, probably more. This is potentially a $1 billion economic development proposal. I have gone through 5 successive years of budget cuts, cutting services, laying off. We're at the bone right now. Chairman, Mr. Commissioner Stebbins would know that. To have this type of tax revenue come in with a host agreement, plus the jobs of anywhere from 2,500, not only white-collar jobs, good-paying blue-collar jobs that put food on their table, insurance, put a roof on their head, plus the construction job, plus driving an aggressive agenda. In the 1990s, and you've done your due diligence, casino operators would come into a city and or a town and say, the box drops here, here's the crumbs, here's what you get. They know, each one of them to a T know that we instructed them outside the box. They've come out with the outside the box mentality with the spin-off effects in our RFP that indicates what is going to maximize the best benefit to the residents, taxpayers, and the business community of the city of Springfield. So I think we're in a good situation where we're maximizing all efforts, unlike other areas where it's one horse in that town. That's all you have, and matter of fact, they're being dictated where to go. I'll look you straight in the eye. I want the best viable proposal for the city of Springfield at the best viable location, not only for the city, but we've told the operators this has to entice and drive a good deal for the Commonwealth of Massachusetts as we move forward. So we're trying to be completely transparent upon this and look for your guidance and advice as we move forward. But just to end, and I'll turn back to Mr. Kennedy and Solicitor Pakula, this is an extremely unique position, which I think appreciate the Gaming Commission and the legislature. This is what you want, competition, maximizing it for the benefit of the taxpayers, residents, and business community of the city of Springfield. Not for somebody to be dictating to the city or dictating to the Gaming Commission, you need to do this, you need to do that, disqualify this, that. That's what we're here to do, and we want to work cooperatively with you.
Well,
Thank you.
I understand that, Mr. Mayor, and I sympathize with that. I mean, we all want to work synchronously and get the best we can, both for the city of Springfield, if it's the winner, and for the region. My concern is not so much with substance as it is with timing at this point. And I'm concerned about Commissioner Cameron's point about the possibility that we find unqualified, and I recognize your assessment is the likelihood is low, but it's not impossible. Find unqualified someone with whom you have chosen to work. But more importantly, the host community agreement under your schedule is going to be signed by January. And it is unlikely, I will tell you, although we're trying to work as quickly as we can, that we will have by January developed all of the criteria for which we're going to be looking in a license application. And therefore, I'm concerned about the possibility that you have a host community agreement that you're ready to put to a vote of the citizens that doesn't, in the end, meet all of the criteria that we're looking for, both for local development and for regional development and for return to the Commonwealth. And how do we then deal with that? It seems to me that we need to work cooperatively in that regard. So I'd welcome hearing from you as to why it isn't possible to hold off on the execution of an agreement and/or the vote until at least we've made and promulgated regulations saying what it is that we're looking for. And what it is that we want to see in the application and what values we're placing on which criteria. Because you ultimately are going to be in competition, perhaps, in all likelihood, with other proposals from other towns and cities.
And
Could I just add one thing before you, I just want to build on that point. This is not, incidentally, an issue only for the town of Springfield. We are in the process right now of talking with Palmer about, and we will be saying to them that from the standpoint of our schedule, you shouldn't close the door on your host community agreement yet, because we haven't even said yet what a host community agreement is going to look like, A, and B, we recommend that you don't have your referendum until after we've approved everybody. The same thing is happening in the city of Boston and the city of Revere. So I would then echo, understand this is not just you guys, this is everybody, many people. The process has moved it quickly on the ground, faster than our process in our 5.5 months in business. But I personally, at this stage of the game, don't have a problem with the RFR. The issue is, as Commissioner McHugh said, can your execution of your host community agreement and your referendum be postponed until it comes after our suitability process?
When would that be?
Well, unfortunately, it's a variable depending on how complicated the applications are. But the time frame as we know it at the moment is that the completed RFA 1, the background check data, will be back to us by the middle of January. We are told by our consultants that a realistic estimate for getting those done is as much as 6 months. It all depends on how much you have to go back and forth on qualifiers.
6 months from January, so that makes
Yes.
it July?
Yep.
Yeah, so
Is that right?
in the nature of 6 months from then, we would be able to say whether people have passed background checks. And then at that point, there's still a long period of time. Our schedule actually anticipates that host communities and developers will do the bulk of their negotiating subsequent to the background check phase being over. There's a good, probably close to a year still, or 6 to 12 months in the process once the background checks are completed.
Well, the situation here on the ground is a little bit, you got a problem with that time frame. We have one operator that has already purchased property and is applying for signage rights and so on and so forth. We have other operators that have already taken options out on property, affecting real estate transactions. We also are trying to figure out what to do with a tornado that came through here a year ago, which went right through one of the proposed casino facilities. Time is really of the essence with us. We can't continue to just wait in an indefinite way The second thing that I would also ask, under the legislation, do we have the right to do what we're proposing?
Well, let me give them what I think our opinion is, and we are working on this very issue ourselves, as you know, and we are interpreting the legislation. I think our belief is that you do, but we may also have the authority to override that authority if we wanted to. We're very clear about the local control that the legislature empowered here. There's no question about that. It was largely anticipated that the process would be at the local level until the host community agreement and the referenda is concluded. But we are empowered with the right to control the, quote, parameters of the elections. And we believe that we probably have the right to set this schedule if we chose to.
Can I just add to that, before we get to rights and who's got what rights, in terms of trying to operate synchronously, which ultimately would be best for everybody.
I agree.
It's clear that you are eager to move forward. We understand that. We're eager to move forward too. We have different responsibilities. We have different things that we need to accomplish. And my concern is, eager as we both are to move forward, if we move forward with competing agendas and competing schedules, we're likely to bump into each other and create a situation in which misunderstandings, conflict, and ultimately do-overs are a potential. And so how do we fix that? One answer is we go faster. Well, we'll go as fast as we can. We can assure you of that. People told us that we couldn't get the Phase 1 regulations out in 5 months. We got them out, as well as doing some other things. We may adhere to Chairman Crosby's schedule. We may be able to speed things up substantially, and we've got that in mind. But suppose we can't, and suppose we come up with a criteria that are not included in your host community agreement that's already been voted on. What do we do then? So how do we work constructively to deal with these two different and not necessarily competing agendas as we move forward and try and get something that works?
I don't know the answer, but except that I do agree, and I think we agree as a city, we would like to work cooperatively, and we're not looking at this as we're adversaries by any stretch of the imagination. But we do have certain needs on our end that I think that you folks need to recognize, and just as we need to recognize some of your needs. And one of our issues here is, we've got 4 or maybe 5 lined up, ready to go, selecting, again, taking options on property. We think that we have proposed a good process, fair, open, transparent, and it's very difficult right now to prejudge it, and really the only way to know what's going to happen is to see how it unfolds. But we know that it worked in Michigan, and we expect that the way that we're going to go about it here is going to work, and it's going to work for Springfield. The question is about timing, I think, Judge, and I recognize that. And I don't know the answer to that, though.
But I'm going to just say, try it one more time and from a slightly different angle, and then I'll stop.
Okay.
You say it's going to work for Springfield. It'll only work for Springfield if it works with the commission's approval, ultimately.
Yeah.
Right? And what I'm trying to avoid, or trying to tease out here of this conversation, and perhaps we can't end it today, tease out a process that ensures that whatever Springfield does and whatever Palmer does is eligible for commission approval, and avoid a situation in which a host community agreement is put to a vote of the citizens who approve it, say, but it doesn't meet the criteria for which the commission is looking. That's for me the largest concern.
And I understand your question,
Yeah.
and I recognize it, but there's no solution that goes with the question. What are you suggesting?
There is.
There is.
At least to wait for that host community agreement until we get the regulations out that outline what it is that we're going to be looking for in the agreement. The license can't be issued before we approve it, in any event.
Right.
And so, whatever else is done, and we'll work as quickly as we can to get the second set of regulations out, but at least outline what it is that we're going to be looking for.
I'm going to have to defer to the mayor on this one, obviously, but
Commissioner McHugh, I just have to point out to the commission, we're operating on three fronts here. As you know, we faced a devastating tornado June 1st of 2011.
Right.
We faced a devastating nor'easter that affected heavily this part of the state. The worst unprecedented weather in the city's 376 years in existence. We're rebuilding off the tornado. We have economic development projects moving, whether it's 31 Elm Street, Court Square, Union Station, et cetera. And now we have the casino economic development project that's in the play. These all have moving parts. Now, when many people thought it was time to turn the lights out in the city of Springfield after we got hit by the tornado and the nor'easter, the exact opposite happened, resiliency. In 8 months' time, not only did we have the place cleaned up, we had rebuilding and we had a plan of attack, how we move forward on an overall vision for the city of Springfield. We want to work cooperatively with the commission. But I'm here day to day. I'm on the street. And it's very difficult to say to the residents of those affected areas who are hungry to work, hungry to rebuild, to say, you got to hold on another 6 months, maybe another year, maybe another 18 months. We have to drive an agenda. We want to work cooperatively with the commission as we move forward, and we want to work in step. But it's very tedious for the whether the business community, taxpayers, or the residents to say, wait. We put a process across. We want to work with the commission, but I think our mettle has been tested of what we've been able to do in unprecedented times, and we understand you're the ultimate authority on it. The legislation does grant, where we interpret it, does grant tremendous power to the local government of the CEO of the city, which I have the honor and privilege of being the mayor on that. So we're here to work cooperatively, but we have to tell you some issues that we are going through here, and it's tough when you're on the street every day and people are saying, when's it coming, or when's a decision going to be rendered or made? And I go back to the unique position that we are in. Who fought for, maybe possibly 6, competing for Springfield? We've welcomed them all. Maximize it. Not being told other areas, we're saying it's going here, this is the one that's getting picked. So that's what I think Mr. Kennedy's alluding to.
we need, let me give you a specific example of one of our difficulties with waiting is. In our tornado-damaged south end, there are 2 very large pieces of property. One is the old South End Community Center on Howard Street, and the other one is the Nettie School. Our tornado rebuild plan says that we will RFP those properties as soon as practical. We are in the very late stages of our negotiations with FEMA, and we will have maximized our reimbursement in a matter of days, if not a week or so. When that comes about, we need to put those properties on the market, according to our tornado rebuild plan. Both of those properties are in the zone for one of the casino proposals. So the question comes up, well, if we wait, are we not only waiting on casinos, we're also waiting on tornado rebuild? We've had a tornado here in excess of a year ago. And we're going to be in a situation where we are supposed to just sit on properties that we've got to get back out on the market, that from a practical point of view, we know full well that the casino company, at least one of them, will be bidding on those. So, I mean, it's one tiny, specific, important example of the necessity to go forward. Not to mention the fact that what happens in a real estate situation where you have an awful lot of speculation and you have an awful lot of options that are being taken on wide swaths of your property all across the city, you know, that's not really the best of all situations. We do think that we have a process that's going to work. And I'm not saying that we don't want to work with you, because we do, but we can't just sort of talk on a level up here. I mean, we got to bring the level down to the ground and actually figure out, how we're going to do this and when we're going to do this.
Let me, it may be that we should talk offline, to see whether we can work this out. But I just want to make sure we're thinking this thing through clearly. If you do your process as scheduled, you will have an agreement signed in December. You would have a referendum sometime in the spring. We will be background checking whoever we get, whoever gives us $400,000 and becomes an applicant. Presumably within that group will be the person that you pick. We will be finishing that process something like 6 months, let's say, down the road. Nothing will happen, nothing will be sped up. We will then, because of your having made a decision, we go through our background check, it takes however long it takes. Then come, let's say for the sake of discussion, June 30th, we have passed people's backgrounds, and we now put out RFA 2, the second phase, for everybody to fill out, including whoever it is that you've picked. They're going to have to take our parameters. You will probably, if you would do it the way you do it, you will probably have been further along the road by some amount of time. I don't know whether that's 1 month or 2 or 3 months, but bet it's not more than 3 months, because you're still going to have to fill out the application. Whoever else competes in Western Mass is going to have to fill out their application. So even if you do yours in a day, anybody else in Western Mass is going to go ahead and take the full amount of time, which is 3 to 6 months. We aren't going to be making any decisions for Western Mass until all of the applications for Western Mass are in. Mm-hmm. Then we will look at it, and once they're all in, we will then make our decision. So, and that will take however long it takes, and that won't be affected by your process. So as a practical matter, the time that you will save could be zero. If the other applicants in Western Mass take the full amount of time that we permit, which is perfectly plausible, to fill out their forms, you will not have saved 1 day. And what you will put at risk is that your bidder ends up, or your host community agreement ends up somehow or other being disallowed.
But we will have lost the opportunity that we have now to have the competition from all of these parties.
You could still go ahead and have that process as soon as you want. You just can't, you won't be executing your host community agreement and having a referendum until you find out for sure that the person that you picked is qualified.
Mr. Chairman, one of the things that you definitely need to understand, a tornado went through here in June of 2011. We are under extreme pressure to rebuild. One of the casinos is in the tornado area. We must be ready, even if it saves us a day. We've got to be ready to move. Our citizens expect that. We can't continue to say to our citizenry, we are not going to rebuild the south end of Springfield because we are waiting to see what the Gaming Commission does. We can't do that.
But Kevin,
So is that where you think the casino is going to go, perhaps?
No, I don't, and it's one of the proposals.
I don't see how they're connected, though. You could bid out whenever that property comes out after the FEMA process. You could bid it out to whomever, whether that ends up being a casino operator or not. That would
Wait a
be.
minute. Now let me put economic development, Mr. Commissioner. You put an RFP out for that. Let's say that one casino company decides they're the top bid, our committee we pick says they deserve to have that property. Nothing moves for 2 years on preferred developer status. Those properties stay as they are, whether the Gaming Commission decides in their wisdom that Springfield gets a bid or not. And then how do we know that we have 4, possibly 6 now, that they're going to get the proposal? So in other words, to the tornado-ravaged citizens of the city of Springfield, they're going to sit back and look at those derelict, decaying buildings until some movement is made by the Gaming Commission, if subsequent. That's what let me say this with all respect, Commissioner McHugh. That's what a mayor on the street has to face. I just can't say, wait, and I know, Commissioner, you're mentioning, well, put it out there. Well, if they do get those buildings on their bid, Mr. Stebbins is aware of these things, economic development hat on, they're the preferred developer. That status will stay in step. That precludes anything else going on a tornado rebuild. So that's what I'm trying to say about the reality of this. So that's when Mr. Kennedy and Solicitor Pakula say, I don't care if it saves us 1 day. We have to be ready to say, here's option A, B, C, and D. if I stand up there and say, I really can't tell you much, I'm still waiting for the Gaming Commission, and we know you have to do your cross the Ts and dot the Is as we're doing, that's what we face, the unique situation, and we want to maximize, unlike other areas that have one horse in that town and being dictated where they should go, what they're going to do. And I would hope you said you brought it about, whether it's Boston, Palmer, if I'm being treated differently here as the mayor of the city of Springfield, the rules and regulations read out the same way. We have maximized the competition here, which is not only going to benefit the city of Springfield, it's going to benefit the Commonwealth of Massachusetts to generate revenues. And I'll tell you again, I don't care where it goes or who gets it, as long as it's the best deal for the taxpayers, residents, and business community of the city of Springfield. That's what we look to do. But that's what we face as far as hold. Those properties could stay derelict, eyesores, quality of life issues, while we're rebuilding left and right throughout the whole city on our own. On our own.
I understand that, Mr. Mayor, and you've made the point eloquently, and I think from my standpoint in asking the questions of Mr. Kennedy, I'm primarily concerned as to how we get a process that works, and that works synchronously, as I said, and that doesn't lead us into a set of false hopes that can't be fulfilled. That's my goal, and I know it's yours as well.
I know, and I think from our perspective, we either need to slow down or you need to speed up.
Or a little bit of
And
both.
I know where we would be coming from on that.
Or a little bit of both. I mean,
I'll echo the comments of my colleagues and understand the urgency. And if there's any benefit for this commission to an issue that we've talked about in the past has been, how do we generate this type of competition across the state? And certainly recognize the mayor's authority, the city's authority to figure out who the best entity or operator is that you want to negotiate. I look at it as if there are people that get kicked out of the process, maybe it frees them up at an earlier enough time that they can begin to consider other locations, either in Western Mass or in the other regions as designated by the statute. So trying to find a solution in that to let you, Mr. Mayor, I'll use your terms, figure out who the pretenders and the contenders are and who you feel is going to have the best project for the city of Springfield. And at the same time, keeping in mind, I think as Commissioner McHugh pointed out, the additional criteria is the law lays out in Section 18 of all the criteria we're going to evaluate a license on. So making sure that your interests are reflected in the agreement you want to strike, our interests in what we want to see is reflected in the final RFA 2 process. But I want to find a way not to slow down that kind of self-selection process that you want to go through to see who has a viable project, who is ultimately going to be, the one or the two proposals you're going to put before the voters. I have a concern about just our coordinating timelines. The financial background, the integrity background that we're going to do. You mentioned not asking or not requiring a bidder to step up with the $400,000 application to us, which until you get to your RFA or your RFP, the second phase.
Which is October.
Which is October. That also in some way inhibits an applicant from even, again, they go in this contender or pretender category, but without that $400,000, we can't conduct an investigatory background. You also know that it limits their ability to interact with state agencies to get a better idea of whether their transportation plan, any environmental issues that they need to talk about with state agencies, that gets limited. I have some kind of just broad questions about the process for you, Kevin, in terms of you look at an election, do you envision an election where you had two proposals on the ballot? Do the voters of Springfield, again, because as we've all talked about, a lot of this was not foreseen in the legislation. Springfield voters be able to vote on one project, on one vote, or can they vote on both projects?
We're anticipating keeping our options open on that. We do believe that one is probably the best. Of the four...
One project or one vote? I
Pardon?
mean, one project or somebody just being able to vote on one
vote.
project?
It-
Okay.
Here's the project, and it's outlined in the statute what it has to say.
Right.
We know that. We want to be able to maximize the competition between the operators before we get to the vote stage. So we would anticipate the competition to be intense at that point. We would also be thinking in terms of having the ability to have a backup plan in case we need a backup plan for whatever reason. I mean, you've outlined some of the financial issues that go with it, and there may be some host community agreements or whatever based on your rules and regulations whenever they come out. So we need to be a little bit flexible there. But I do believe from an electoral point of view, remember, we are going to be in a full-fledged electoral campaign. The airwaves are going to be full, the newspapers are going to be full. I mean, it's going to be like an electoral campaign that we haven't seen on a political basis in a long, long time. There's going to be a lot of chaos and a lot of noise out there, so it's going to be really important that we not only stay grounded, but that we keep the questions as narrow as possible. If we are doing multiple questions, I would fully anticipate difficulties with the election situation. You know, there may be those that don't agree with me on that, but I do think that it's difficult with multiple questions. So the simple answer to your question is, we think that there should be one, but we'll keep our options open in case we have to have a backup plan.
I think, if I could make one last point, and that is, everyone up on stage right now is dealing with something that's brand new and a process and a statute that none of us have really seen before. But our consultants are here, and they've been through this process before on both sides. And so they may be able to provide some enlightenment on some of these issues and some of these questions beyond our capabilities. And so they are here to speak, and perhaps they could talk about the experiences that they've had in other jurisdictions. And I think Massachusetts has this fairly unique local control mandate, which we don't see in some other states where everything is controlled at the state level. And I think that the legislation here draws on the shortcomings of other legislation, and so maybe our consultant could address some of your concerns more in depth and better than any of us could.
Well, before we get to that, I think Commissioner Stebbins said he had more than one question? Did you?
Yeah, I may save some of my questions for Shevsky and Freilich. You talked about going to an operator to secure funding to do a number of studies. Because of the different potential locations, you're going to be studying different topics. Do you foresee a scenario where you would ask one operator for more money than you might ask another operator for funds, just based on what you need to evaluate?
No. No, the process will be baselined. I mean, there will be a fee for the first round, there'll be a fee for the second round, and those fees should be sufficient to cover all the studies that I mentioned in my remarks.
Okay. And then let me throw in the last one. You talked about taking an operator to a host community to negotiate surrounding community agreements. Mm-hmm. Obviously, it kind of puts the onus back on the operator to do that, but you see the city of Springfield kind of doing that hand in hand with an operator that you favor to.
Well, I think we believe that it's the operator's responsibility, but I think in the background, we will be saying to them that this is a regional project, we want a regional benefit, you should be making, you need to be making agreements with the region.
Okay.
So, and that will be prior to anything going on the ballot, so we should have some leverage. Again, we need to make sure from anybody that's ever been in a negotiation, it's all about leverage. And we need to maintain as much leverage as possible. I mean, these casino operators are offering a great deal, but I don't for a second think, how can I say this? I don't want to insult anybody, but first, I don't for a second think that they are going to be choir boys about how we go about the process. So we want to be fair and we want to be above board, but we are not going to be pushed around.
Thanks.
Thank you all. I think I would like to hear from Shefsky and Freilich if they have things to add. I do think it makes sense. I do think thinking through this timeline carefully and seeing whether there's wiggle room in either of our positions is worth doing. So maybe we can follow up.
I'm willing to talk in
quickly.
the
Yeah.
next couple days,
Yeah.
but again, time is of the essence
Right.
with us, so if we can talk in the next couple days, I'd be glad to do that, if that's all right with the mayor.
Yes, it is.
Yeah, all right. Mr. Mayor, my wife says, Mr. Mayor, that small city mayors is the Vietnam of public service, so you have our admiration. We sympathize with
First of all,
your issues.
it's not a small city, Mayor. We're the third largest city in the New England. Tommy Menino, my friend Tommy, has Boston and Worcester, but it's mid-size, and whether it's small or not, or large city, I'm out in the street, so appreciate that.
Thank you.
But we don't have a small city mentality when it comes to negotiating and striking the best deal for the city of Springfield.
We got that.
Good
Welcome.
afternoon.
Do you want to introduce yourselves?
I certainly will. I'm Michael Schaller of law firm of Shefsky and Freilich in Chicago. Next to me is Kimberly Kopp, my partner. The third member of our Springfield team is on a planned vacation in Italy. He wishes he could be here, but he said that he was more concerned about his wife than anything
Getting
else.
divorced
so-
if he left early.
First of all, thank you for inviting us to speak with you today and allowing us to provide some input. I've heard our firm described as high-powered and firepower, and I guess that's a compliment. I prefer to think of ourselves as experts in this field, and I know there's been a lot of talk in the media about this appearance of conflict, and I'll get into that towards the end of my presentation. I'd be happy to welcome any questions that you may have in that regard. But as Mr. Pakula indicated, I will address the selection process issue. One of the, I guess, drawbacks of being last in a panel like this is some of what I'm going to say you've already heard, but let me indulge me, if you would, to lay it out at least from my perspective and in my own words. As you've heard, the city has settled on a two-phase RFP process for selecting the company or companies with whom it will negotiate a host community agreement. So let me first explain how the city administration, again from our perspective, made this decision, and then let me explain the process in more detail. At one of our first meetings with the administration, we discussed two alternatives for the selection process. One alternative involved negotiating host community agreements with all bidders and then submitting those agreements to the voters for the ballot that's required by the Act. The administration determined that negotiating and submitting multiple host community agreements presented the following issues. Number one, first and foremost, voter confusion. Would the city have to schedule multiple ballots? Which agreement would be voted on first? Would residents even vote on the first proposals if they knew there would be no additional proposals coming? Should the city place all proposals on the same ballot? Under the Act, the applicant requests the ballot measure. Would the applicants agree to placing all the proposals on a single ballot? Which proposal would be listed first? Would the voters get confused trying to understand multiple proposals? Number two, one of the issues in negotiating host community agreements with all bidders is the need to spur competition. As the mayor has said repeatedly today, the city is looking for the very best proposal to present to the voters and to the commission. If all proposers have the right to negotiate host community agreements, would they be incented to bring the city their best proposal or only a proposal that meets minimum requirements. Third, use of scarce resources and time concerns. And I know this issue is one of the hot issues here. But from the city's perspective, we felt that if the commission had to vet and evaluate multiple applications from Springfield, would that cause the commission to spend money and time on a process that it didn't have to? Wouldn't it streamline the process and speed up the timeline, which, as we've heard today, is of primary concern to the city, if the commission had only one or two applicants to focus on? Well, due to these issues, we advised the city that they follow the same two-phase selection process as was used successfully in Michigan. And let me just add as an aside that the two of us and our partner, Mr. Freilich, were the team that represented the city of Detroit on its multiple casino selection process. So we are intimately familiar with what went on. In the two-phase RFP, as has been mentioned, the first phase is for pre-qualification. The goals of phase one are threefold. Attract as many qualified bidders as possible. As has been mentioned in the media, there's a report, and we have met with, we being the administration, have met with 4 possible bidders. Our firm has received inquiries, telephone inquiries from other bidders who are interested in coming to Springfield. So the idea here is to cast as wide a net as possible, again, to spur competition to come up with the best proposal. Second goal of this pre-qualification process is to determine which bidders are serious bidders, the contenders and pretenders, and have the experience, development capabilities, and financial ability to develop and operate a first-class project. The question has been raised, and it's a good question by the commissioner, of how can we do this in 5 days? How can we conduct a financial capability analysis? Excellent question. The answer is we can't substitute what the commission is charged by the act to do. We do not have an investigative team. We are not going to put the proposers in phase one through those type of paces. Our experience in Detroit was that the first phase, besides, as I say, gathering in as many proposals as possible, was also designed to eliminate what we facetiously referred to as 2 men in a rowboat who said, if you give me the license, I can get the money. We're trying to eliminate those should any of those appear on the horizon and want to make a bid for or want to submit a phase one qualification. Phase one will ask approximately 15 questions, enough to give us a sense of who is a serious and qualified bidder. As has been mentioned by Solicitor Pokula, in phase one, the bidders will be required to make a non-refundable deposit to pay the city's consultants. Phase two, which, depending upon how all the timing works out, we would hope to commence in October, is a lengthier and more intense process. In phase two, the proposers will be required to sharpen their pencils and put forward their best proposals, particularly concerning the design of the project, its various features, and how the project will showcase the city. As has been mentioned, in a situation like Springfield, where you have an urban environment, is far different than what you see in, say, Atlantic City, where the casinos are all clustered along the boardwalk, and we have done work in Atlantic City. It's far different than what you see in Colorado, where we got our first experience in dealing with casinos. In Colorado, there are 2 streets, and anybody that has a storefront on those 2 streets can have a casino. It is far different than the structure we have in the state of Illinois, where all riverboats have to be on waterways, although that has been recently a little bit more liberally, loosely interpreted, but places those boats a little bit further away from the urban center. That's why the design and as the mayor has said, the outward-looking features of a casino are so important to a city, and why this has to be a major part of the evaluative process. It's not only whether these casino operators are financially capable, it's not only what their projections show, it's not only whether they pass a probity and suitability test, but how are these casinos going to fit within the urban fabric of the city of Springfield. The license term is 15 years under the Act. I'm sure that every casino company expects that they will adhere to all the rules and regulations and have those licenses renewed multiple times. That means that these developments reasonably will impact the city of Springfield for generations. That's why it's so vitally important that the city play not only a big role, but that it focus on this issue of the design and how it fits into the urban landscape. Phase 2 will also solicit information from the proposers concerning impacts on the city and the proposers' plans for mitigation of these impacts. Again, in Phase 2, similar to Phase 1, the bidders will again be required to make a non-refundable deposit to cover the city's costs of its consultants. There's been some talk today by the other presenters about Michigan. So since we were so intimately involved in the process there, let me explain what happened there, and I think it'll help shed some light on the Springfield process. Michigan authorized 3 casinos in the city of Detroit. Michigan, like Massachusetts, required that each community, each casino, have a host community agreement. Of course, in Michigan, the only host community was Detroit. 11 proposers responded to Phase 1, and this was after receiving dozens of inquiries from companies that expressed an interest. 11 proposers responded to Phase 1. Of those 11, 7 proceeded to Phase 2. From those 7, 4 were selected for further consideration, and then 3 finalists were eventually named by Mayor Dennis Archer. That process, to the point made earlier, the question asked by one of the commissioners, it was a subjective process based upon enumerated criteria, similar to what we're recommending for the city of Springfield. There was not a point system put in place. As the city there, Mayor Archer said, there were too many factors to weigh, too much subjectivity, and ultimately he had to make the call. It was his call under the state statute in Michigan, just as it's Mayor Sarno's call in the city of Springfield. And so if it was his call, he was going to do it the way that he felt best represented or best was the best proposal for the city. And again, in Michigan, in Detroit, all costs incurred by the city in connection with the selection process were paid by the casinos. Just to give you an idea of the timeline, from start to finish, the Detroit selection process involving 11 proposers took less than 5 months. And today, Detroit has 3 of the most successful casinos in the country, generating over $1.4 billion, that's billion with a B, in gaming revenues in 2011, something we hope, we aspire to be able to do here in the city of Springfield. We believe that
Excuse me, this was 5 months from the time
the selection process, the
Just
selection
the
process,
Detroit
the
process,
city
yeah.
selection process. Michigan, the Michigan statute was different in one significant respect from the one in Massachusetts, in that it had a preference for 2 enterprises that had paid for and had promoted the legislation. So that was written in that, those preferences were written into the act and was successfully challenged by a Indian tribe on First Amendment grounds. I won't get into the details, but that delayed the ultimate process by a considerable, the ultimate opening of the casinos by a considerable period of time, or the permanent
It
casinos.
also didn't,
correct.
the legislation also did not have a referendum, right? There was no referendum to approve
Well,
the host community agreement.
yes and no. There was some additional, now this is thinking back a number of years, there was a vote that was required for, to amend the act. It was not a referendum as such, but there was a voter requirement as things turned out. As an aside, host community agreements are required for the proposed Illinois gaming expansion that you may be aware of. Our firm represents both the city of Chicago and the city of Rockford, Illinois, and we have advised them similarly that a two-phase selection process likely results in the best outcome of those cities.
Quick question, if I
Sure.
can. And obviously, the statute, as the chairman pointed out, was pretty clear that I know other Midwestern states or central United States have done this. I know when they passed gaming in Ohio, it was specific to individual communities.
Right.
What was the timing of the passage of the Michigan statute to any regulatory process they had to create, and how it coincided or synced up with
Yes,
the
good,
process in
good.
Detroit?
I'm glad you asked that question. In Michigan, the way the process worked was, again, the statute mandated that before an applicant could apply to the Gaming Commission, they had to have what the statute called a development agreement, which is the same thing as a host community agreement under the Massachusetts statute. So the process was the city had the two-phase selection process, settled upon the three finalists. We contemporaneously negotiated 3 agreements with the casino companies, one of whom, I might add, was MGM. After that was completed, then the licenses were submitted, license applications were submitted, and the Michigan Gaming Control Board conducted its suitability and probity review.
How did the suitability tests go, background checks go?
Well, a very good question. All 3 casinos were licensed. There were 2 principals in the Greektown casino enterprise that were found to be unsuitable. Those two individuals who were actually controlling members of Greektown, they were not 1%, 2% members. They were majority owners along with the Sault Ste. Marie tribe of Chippewa Indians, which was a minority owner. Now, this was not an Indian casino, Native American casino. It was a commercial casino. One of the investors happened to be an Indian tribe. And because they were found to be unsuitable, the Michigan statute provides that if you have an unsuitable member, that member has to be redeemed out. His interest has to be purchased so that the applicant can move forward. And again, to the issue raised by one of the commissioners, while yes, it is absolutely a risk and a possibility that this commission could find the license applicant selected by the city of Springfield to be unsuitable. Having practiced in this area now for over 20 years, the more likely outcome, not the only outcome, but the most likely outcome is that the commission, pursuant to its powers, would require that that unsuitable person be purchased, be redeemed out, so that they would not participate in the casino license. So again, that is something that we have seen many, many times throughout the country.
Could I ask another question?
Sure.
When in relation to commencement of the Detroit process was the Michigan Gaming Control Board created?
Wow.
I think it, yeah,
I think they were
went on.
formed, but they don't know if they had, they certainly did not have all of the regs and rules adopted and
Right.
out.
It was much the same situation as we have here. We had the good fortune of working very closely, and this is to the point of the cooperation that the mayor spoke about and that CDO Kennedy spoke about. We developed, we being the administration in our firm, developed a very close and excellent working relationship with the late Nelson
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 Westren. He was
Westren.
the first executive
Right,
director of
first
the Michigan
executive
Gaming
director.
Control Board.
And so anytime that an issue came up regarding licensing, suitability, the development agreements, the host community agreements, we were able to work through all of those issues with him. So my recollection is, and it's a little, I don't remember all the details, but it was very close to the situation we find ourselves in here in Massachusetts, where we were able to move forward on parallel paths, and it, as I say, it worked out very, very well at the end of the day. And again, just to continue, and this has been said before, that we recognize that having the host community make its selection first, there is this risk that the Gaming Commission will find the applicant unsuitable, resulting in a delay before the casino can get up and running, which is the last thing that either the commission or the city wants. Springfield believes that the risk of a significant delay is minimal for 2 or 3 reasons. One, as has been mentioned before, we're dealing with world-class casino companies licensed in multiple jurisdictions. And yes, it is possible. We are aware of casino companies that do decide not to pursue applications in particular jurisdictions or have been asked to leave particular jurisdictions because there is a problem. Again, in the situations that we're familiar with, that was because the casino companies refused to buy out the unsuitable persons who the commission refused to license. So that, in our experience, and I can't say we know every situation, but in our experience, it was a sort of a forced voluntary withdrawal from the jurisdiction.
I had understood that all 3 of the selected parties had some kind of an issue with their financing or some of their principals, that all 3 of them had to restructure their deals.
In Detroit?
Michigan. Yeah.
MGM did not.
Okay.
No.
But if that, whether it was 1 or 2 or 3,
Yeah.
That's precisely the issue. And when you say redeem an interest, you don't just turn around and flip a switch and go buy a guy out for a $500 million or $250 million piece of it. That's a fairly major restructuring that has to take place.
Yes.
Which
Yes.
is going to which is going to take some number of days, weeks, months.
Yeah,
which has got to be akin to whatever possible savings could possibly be pulled out of the process by doing it in advance. I don't understand why you would recommend to the city that they do it prior to our description of a host community agreement, A, and B, prior to the suitability. I don't see why you would recommend that.
Again, our experience is that the redemption of unsuitable persons was done very, very quickly. It was done through one situation I'm thinking of specifically was done with a promissory note that was paid out over a period of time. So it became very clear that person, in other words, you have parallel processes here. You have the 6 to 9 months that it takes to vet and do the probity suitability review During that period, you're looking at the company itself, you're looking at its financial capabilities, and you're doing an investigation of the actual individuals involved, the key persons. And when you find that, when it becomes apparent that there are one or two or whatever unsuitable persons involved, that repurchase process is going on at the same time, with those negotiations is going on parallel to completing the probity review.
What about the second question from the
Yes.
chair? Because there's an element here that he's drawing to, which is we are in the process of only beginning to think about the details of the Phase 2 regulations.
Yes.
Which will include things like guidelines around host community agreements.
Yes.
The
Yes.
elections that would take place. That
Yes.
has not been promulgated. We have only promulgated the Phase 1.
Yeah.
So there's this other milestone lingering further that I'd like to understand,
Yes.
same as the chair,
would
why
we
why
handle
would you recommend that the
Yes.
city
Let
do
me
not
ex-
wait for that?
Let me explain how I would recommend, and we have not had this discussion, but how I would recommend handling that situation. The casino companies know, obviously, that having a host community agreement is only the first step in this process. They know that they have to be licensed by the commission. What we would recommend is what I call a reopener in the host community agreement, where the casino company would agree that to the extent that the commission comes up with requirements that are not in the host community agreement, that they negotiate with the city in good faith to resolve any of those issues.
And how would you determine whether that required another referendum?
Well,
Well, it
we-
depends
it
on what
would,
you
it would,
change.
well, it would, first of all, it would provide in the agreement itself and in the summary of the host community agreement that this was a possibility. So voters would go into this with their eyes wide open. Let me also say that the way we envision the Phase 2 process to work is that we would be seeking responses to many of the same issues that the commission is seeking information on. For example, workforce development. Workforce development is extremely important to the city of Springfield. That's part of your statutory requirement as one of the criteria that must be responded to by the applicant.
We're not going to differ on the ones that we agree on.
Right.
I agree with that. But there is and this is not a rhetorical question. There
No.
really is a question. You know, you, just as a matter of fact, you did not see the potential that you represent, two of the potential bidders, as something that was worthy of an ethics opinion. We did. We see, by that example, we see some substantive issues very differently. We may well see something in a host community agreement which is unusual, which you have not anticipated.
Right.
And given the fact that the amount of time that could possibly be saved by this expedited process,
Right.
given the sequence of events that I just walked
Right.
through, is at best very slight.
Right.
Why would you run the risk of proposing to your client
Right.
that they approve an agreement
Right.
prior to us saying what should be in the agreement?
Right. There are two parts to that. One is a legal response, and the other is the policy response. I think that Mr. Kennedy responded quite eloquently to the policy response, which is this cloud hanging over certain key parcels in the city while the process is going on, and the desire of the city to eliminate as many of those clouds as possible, okay? As I said before, I think the legal response to having a requirement being imposed by the commission, which would be properly includable in a host community agreement. I think that's the question you're putting to me, if I'm hearing you correctly, that you would come up with a requirement that you would want to see in a host community agreement. If it's not in the host community agreement, it doesn't impact the city. So to the extent that you came up with a requirement that we did not address in the agreement, or did not address in a way that was satisfactory to the commission, we would have a provision in the agreement that would say that the parties would reopen the agreement in order to accommodate that requirement. If the casino company said, we're not going to discuss that with you, City of Springfield, well, it's a requirement being imposed by the commission. That's why I don't see, I mean, I hear the hypotheticals here, and believe me, I hear them, but I don't see the conflict.
Let me just take
Sure.
that. Suppose you have a reopener agreement,
Right,
and you put the new term in the agreement.
right,
Suppose the commission's criteria are, in addition to the substantive criteria, that the host community agreement has to contain all material terms of the agreement between, the host
Right.
community agreement put to the vote has to include all material terms of the agreement between the developer and the city. And
Right.
suppose the additional term is material,
right.
that necessarily would require a new vote, right?
Certainly.
I mean, we're,
It's possible.
possible,
It's
yes.
possible.
can't imagine what you're gonna put in this host
Dealing in the
community agreement.
hypothetical, it's difficult to respond, but again, I think that legally, we can reopen the agreement to cover that material term. I would have to consult with Solicitor Pikula as far as the election laws go for the city.
well, I'm trying to make this as simple as possible.
Sure.
If we say the the commission can establish
Right.
parameters, and if we say that the host community agreement has to include all material terms of the agreement between the developer and the city,
Correct.
and the first host community agreement does not include something that we all can agree is a material term,
Right.
then we're in revote land, aren't we?
Well, I don't think so, but I suppose it's possible. I mean, again,
I
you know,
admit it.
dealing in hypotheticals, I suppose the commission could say that no host community agreement executed before a certain date is an
Yeah.
acceptable agreement.
Right.
It's certainly possible. We're dealing with the facts as we know them today, which is a statute that says that a city shall have a host community agreement. We're trying our best to put something on the table that works for the city and for the commission.
And I understand that, and I'm not trying to cross-examine you and pin you into an untenable position with hypotheticals. But doesn't that exchange illustrate the danger of proceeding with a vote before we have decided as a commission what the criteria? I gotta finish.
Yeah, I'm sorry.
Before we have decided as a commission what the regulations governing host community agreements are. I mean, these risks may never come to pass. On the other hand, they may.
And if
Why
that's the
take-
case, what's the result? The result is, have we lost time? I mean, we're putting forth a process that we believe will work. Is it possible that the commission decides that a material term has been omitted? Is it possible that we conclude that it require a new vote? Yes, it's possible, but what have we lost? When we have so much to gain from a policy standpoint, and as the mayor has so eloquently said, from an urgency standpoint, what have we lost? If that's what we end up doing, okay, and I guess it's a possibility, okay, then okay, that's where we're at. But to deny the city the opportunity to try and push this forward as quickly as possible, my perspective is a mistake, And I understand the desire to vet all these companies first It's a 6 to 9 month process, as anybody who's been through this knows. It can be excruciating, okay? We believe, again, reasonable people can differ, but we truly believe as we sit here today that our selection is going to be acceptable to the commission from a suitability standpoint. We're not trying to put you in the box and say, oh my God, if you know, we'll have to start over again or anything like that. You've got to do what you've got to do. The city has to do what it believes it's in its best interest, which is to get this process moving as quickly as possible in order to create all the economic benefits that have been discussed.
I had a question regarding the suitability investigations that we will be conducting. I'm hearing today that you will, phase 2, you will be recommending that the prospective bidders in the city submit a $400,000 check. Is that correct?
I'm saying, and I have prepared remarks that we're going to give you, that is something that we could do. We have discussed it with the administration, and it's something that they are willing to consider.
Which means we will be conducting, if that's the case, we will be conducting these suitability
That's
investigations on all of the prospective
That's
bidders.
correct, and that's a decision that you can make. So let's say we get to the point where we sign up one or more host community agreements, and you have, let's say we have 4 bidders, and let's say we put into the phase 2 process that they must submit the $400,000. You now have applications in front of you, possibly sooner than you otherwise would, possibly. We submit to you 2 host community, 1 or more host community agreements. You may decide then to reorder your resources. I don't know what your plan would be at that point. You may say to yourselves, well, we only have so many resources. Let's concentrate them all on the 1 or 2 applicants that have host community agreements, thereby speeding up the process. You may decide you don't want to do that. Again, that's a decision that you have to make, that we can't
It wouldn't make
make.
any difference because there are likely to be other bidders from Western Mass who will be going through the ordinary process. You cannot shortcut the process that takes place in Western Mass, no matter how quickly
Right,
you
no,
move.
absolutely not. I was addressing the question of whether the city, I believe the question that was asked was
I understand
why
that,
wouldn't
yeah.
the city wait until the commission finishes? And what we're saying is, we can't tell the commission, obviously, what to do, but you might consider the possibility if we submit to you, let's say we submit 1, okay, from the city of Springfield. You may decide to put your resources, more resources to that 1 applicant first, and if there's 1 from Palmer to Palmer at the same time, rather than putting your resources to multiple bidders from the city of Springfield. That's a decision you're going to have to make, but at least we've teed it up in a way that we think could streamline your process should you choose to do so. That's the only point I'm trying to make.
I think we're retreading trod ground.
I think so. Let me move on
Okay.
if I can. Let me get to the other issue that is on the table, and that is the issue that's been raised concerning the appearance of a conflict of interest involving our firm. And let me say, we take this very seriously. We operate in an industry where integrity is paramount. At the same time, our firm has had a gaming practice for over 20 years. As you would expect to become an expert in this industry, you have many gaming clients. As reported in the media, our firm is registered in Illinois as a lobbyist for MGM and Penn Gaming. Let me explain what that means, because I think it conjures up in people's minds something that it is not. In Illinois, as in many other jurisdictions, anyone who represents a gaming company in front of a commission must register as a lobbyist. We do not work for these companies to change legislation or do anything of the sort. The only work we do for these two companies in Illinois is representing them on their routine regulatory matters that come before the Illinois Gaming Board. That's licensing key employees and providing guidance on complying with the Illinois regulations. All of this work, and let me repeat that, all of this work is performed by one of our partners, Mr. Paul Jensen. And if you take a look at the CVs that were attached to our RFP, as a matter of fact, that we submitted to the commission initially, you'll see that Mr. Jensen indicates he is the Illinois representative of MGM. Mr. Jensen has not been on and will not be on the Springfield team. Similarly, no member of the Springfield team performs work for MGM or Penn. This is the way law firms traditionally, customarily handle these potential conflicts of interest. They separate themselves. As you can imagine, we're a small law firm. We're about 70 attorneys in the city of Chicago. We're a small law firm. You have law firms with thousands of attorneys now throughout the world. It is inevitable that these law firms will have certain conflicts of interest in the way that the profession has developed, or what the profession has developed is a mechanism for separating out these conflicts. Obviously, you can't have a direct conflict. I can't show up in court representing a client and another one of my partners show up in court representing the party on the other side. Those are direct conflicts. Mr. Jensen, we have followed those customary practices. Mr. Jensen has been completely walled off or isolated from all information concerning Springfield. Further, no member of the Springfield team is compensated based upon the firm's work for Penn and MGM. I went back and checked the numbers. In 2011, the work we did for each of MGM and Penn represented less than 0.5% of our firm's revenues. As Mr. Pikula has advised the Commission, our representation of MGM and Penn was fully disclosed to the city when we were selected as consultants. In accordance with Massachusetts ethics laws, we filed Form 23B3, which is a public document that will be an appendix to the RFP Phase 1, which will advise everyone of exactly what we've done in the state of Illinois and why we believe there is no conflict of interest here. And to the point that was raised on August 31st, our firm requested an opinion from the Massachusetts Ethics Commission that we have complied with applicable ethics laws. The reason we did not file it ahead of time is that in our view and in the view of Attorney Pikula, there is no conflict. The two teams are completely separate. And I spoke to the attorney for the Ethics Commission on Friday. He was hoping he might get to it on Monday. I did not hear from him on Monday. I have not heard from him today. I do expect it soon. I impressed upon him the urgency of him completing his work, and he said he was mindful of that and would do so. And we're confident that it will confirm our belief that our representation of Springfield will be fair and unbiased. And let me sit here today and look you in the eye and tell you we will act in a fair and unbiased manner. And I think it is unfair to the firm due to the fact that we're an expert to raise this issue or somebody to conclude that we would have bias in this situation. We cannot operate in this industry if we choose sides. We have to be unbiased experts when we represent governmental bodies in this industry. So that's all I can say on that. And I know I'm passionate about it, but I feel very strongly that we have been, I won't say attacked, but our professional professionalism in this regard. Questions have been raised, and that's just not right.
Question, sir. Will you make that, that ethics opinion public when you receive it?
Yes, we will.
And have you thought about if the commission believes there is a conflict or a perceived conflict, have you thought about
The Ethics Commission.
What
the
our
ethics commission? Yes.
What our response might be?
Yes.
It depends what it says. It really depends what it says. For instance, it may require us to withdraw from representing the two companies in Illinois. That's something we might want to consider if that would solve the problem. I don't know. Dealing right now from where we sit, we're confident that they're going to support our position, but should they raise a question, we'll address it at that time. And yes, we will share it. Again, transparency, we've been instructed by the administration to be open, candid, and transparent on all issues, and so we will make that available.
You apparently also did not think that there was an appearance of a conflict. That a reasonable person might look at the fact that you represent these companies.
That's not the case. That's why we put it in our RFP response.
but I
We
thought-
were asked about this issue, and that's why we responded.
But I thought that happened after this whole kerfluffle started.
No, that's in our RFP response.
Oh, the 268A?
No, a full explanation of our representation of MGM is included in our response to the city's RFP.
So you
And they
did
engaged
understand
us.
that it could possibly be perceived as a conflict in the
Well,
outside
I
world.
suppose, yes, people
Yeah,
who don't know the facts.
But then why didn't you file the 268A for 3 months later, till this became a problem?
Because it's our conclusion that there is no, to us, it's so clear that there is no conflict. And yes, always looking in hindsight, now having people say, well, oh my God, they don't understand it. I really think it's rooted in a misunderstanding of or a not understanding of of how our firm has handled this particular issue. So, I don't know what else to say about it.
It might be rooted in that, or it might be rooted in a misunderstanding of just how incredibly sensitive these issues are. I think either is possible. Are there other issues that we want to?
I just
Follow
have
those
a
folks.
couple follow-ups. Is there you keep referring to the Michigan process. Was there a investment floor when it came to a requirement for the casinos?
My
and the
recollection is
drink-
there was not. No, there was no investment floor.
Not in the
Although-
statute.
Not
The
in
city
not in the
imposed.
statute, but the city imposed that
Right.
in its host
its
community
RFP.
agreements.
And what was the city's requirement?
It was different, well, the city,
it was
well,
different.
one thing that what the city really dictated was what you're going to build. Are you going to build just a casino, a slot parlor? Are you going to build a hotel? Are you going to build 7 restaurants or 4 restaurants? So what the city dictated was more of criteria of, you have to, what in the RFP process, what I want to hear back from you is a full casino complex. And that complex must have a minimum of 800 hotel rooms. It must have a minimum of 150,000 square feet of gaming. It must have at least 4 restaurants. It must have at least, if we had a square footage of convention space or meeting space. So
There was no
There
number,
wasn't a
if that's what you
dollar
were asking.
number.
But of necessity, because of the scope
Right.
that the city was requiring, they
Right,
had
they all
to be
proposed-
a very
the
significant
lowest proposal
investment.
was 550 million, the largest was 750, 800 million. They each proposed something different.
Okay.
Excuse me.
One thing that hasn't been mentioned, that I did want to mention is, this is the same team that represented the city of Taunton, which again was attractive to us, that they had been in the state, and they had familiarity with the statute, the lay of the land, and so again, that was another aspect. That they have already successfully guided Taunton through a process which included the referendum process. And so Taunton, again, is waiting for other governmental agencies to carry out their due diligence and other aspects. But the local part is done, and we would like to be in a similar situation, recognizing that it may not be over.
Thanks.
Anybody else?
I just have a very minor question.
Sure.
But you mentioned in your phase one, the phase one that you're proposing or articulating for the city as to find out who is serious.
Yes.
Or who is really just, not. Wouldn't it be, if the city was to require in that phase one that the proponent become an applicant to the commission by submitting the $400,000 application fee that the statute stipulates, wouldn't that weed out those who are serious and those who are not?
Yes, I mean, certainly, it would do that, but it also might discourage people. Look, right now, we think we know there's going to be 4 bidders until we actually see them come to the table. We don't know. So we felt, at least in phase one, by putting in that kind of requirement that they had to pay $400,000 to become part of phase one, might discourage people who didn't want to write the check at this point in time. I mean, again, hypothetically, it could be that we get two other bidders in, and the 4 who have announced decide for whatever reason they're not gonna play. We didn't want to discourage people in phase one. And again, because the time period between phase one and phase two was so short, we just felt it was a better approach to make it easier and more attractive for people to, to consider competing in the city. But yes, we could have done that.
Yes?
My biggest concern is the conflict between procedures. I fully appreciate the point the mayor has made. Let's negotiate with the people who are serious. Let's find the best project, et cetera. And this what you're suggesting is a process to hopefully weed out the people that may not have the best proposal for the city of Springfield.
Right.
But it seems to me you're, and I don't have enough details about the Michigan process to see how this lines up, but you're overlaying a process you used in Detroit, which did help you winnow down contests. And again, I don't really know Michigan Gaming Control Board's responsibility in that process, and even where they were at the time the local selection process occurred. But can you see a process for Springfield to narrow down its list of suitors to 1 or 2 that meet the priorities for the city of Springfield, but don't trip up or don't potentially run into a conflict with the process we have to undertake?
I think Mr. Kennedy addressed that and very succinctly, and that is we have to slow down or use speed up.
And we're trying to do both.
So maybe there's a way to meet in the middle here. I don't know. That's a policy decision that I really can't speak to.
But we're just in general economic development practices.
Sure.
I mean, and maybe the gaming sector, and it's new to us here in Massachusetts, so maybe it's a little bit different. But establishing some level of predictability in a process is key for any business venture, and I would assume this extends to gaming, to say, I know what the process is, I know what the time frame is.
Right.
I know what the expenses are going to be.
Right.
And at the end of the day, if it's a process I can follow,
Right.
then I kind of know where I'll shake out at the end of the day.
Right.
But if coming back and renegotiating a host community agreement, and again, share with me your experience if I'm not on track with this.
Yeah.
I think would cause an increased level of frustration for an operator to say, I got to go back to, hopefully they want to be here, and that drives their passion more than
Look,
The process.
you're always balancing interests here, and I think that's sort of the crux of the issue here on how we're going to go about doing this, and it's helpful, I think, to air all these things right now. I could turn that around, and I'm not trying to be clever or cute, and that is the alternative of having the developers who have many opportunities in many jurisdictions, and as well-to-do as some of them are, have limited resources. Now you're saying to them, well, stick around for the 6 to 9 months that we think it's going to take. Now, we don't have an executive director yet, we don't have general counsel yet, so maybe we'll be off by a little bit, but we think reasonably it's going to be 6 to 9 months, and sometime into next year when we've completed our suitability. Stick around, continue paying the option fees, continue being a presence in the city, versus the process that the city is proposing, which is you have some degree of certainty, okay? Not a complete assurance, but some degree of certainty that by sometime in December or spring, when the vote takes place, that, you know, you got a good chance here. You passed the first hurdle. So I think people, again, this is a balance of different interests here. We all have the same goal to get to the finish line as quickly as possible. We happen to see it, the city happens to see it a little bit differently than the commission sees it. The city would like, for policy reasons that have been articulated, to possibly eliminate several of the bidders faster. Again, giving the commission the resources to focus on those if they so choose, and thereby get this done quicker. Again, you're all raising good questions. This statute is new. While it's similar to Michigan, it is not identical to Michigan. And I think that, as has been said, we can work together to find out a process that will satisfy, you know, your needs and our needs. But I've sat in meetings with the city, and they are loath to sit around for months and months and months, you know, until they arrive at you know, doing their selection process.
Can I just go back to a point that you made before, which was the other alternative that the city contemplated, which was to negotiate with all of them. If they had done that other alternative, they would not be sitting around in the scenario that you described.
Yes, and I think in that case, as I tried to point out, I think that there are, well, not insurmountable, certainly significant challenges to doing that from the voter, what I call the voter confusion issue. We don't know how that would work. We'd have to figure that out. From the fact that we don't think we would get, most importantly, the best proposal, because people now feel that, well, I'm negotiating, I'll meet the minimum requirements, I don't have to have, Penn doesn't have to beat out MGM, Maristar doesn't have to beat out, you know, Hard Rock. So it doesn't spur the kind of competition at the outset that the city would like.
I'm going to disagree with that, but I think we've talked a lot about it.
Yeah, right, I think so too. I think we've beaten this horse
I'm happy
to
to
death.
keep
Right.
responding to questions, but
No,
I
think-
agree. I think we've sort of beaten this to death.
I think we got what we were looking for.
Good.
We will talk amongst ourselves and decide what, if anything, to do further on this, but we very much appreciate your time.
Thank you.
Your time, Mr. Mayor, and your staffs, Mr. Pakula, Mr. Kennedy. We will be in touch ASAP with Ed and Kevin and see whether there's anything to talk about on this. And we will think about the ethics issue as well. Hopefully, there'll be a decision there ASAP.
I hope so, too.
We're going to take a brief, like 10-minute break. It's been almost 3 hours, and then reconvene for the rest of our meeting. Thank you, Mr. Mayor.
Thank you, Mr. Chair.
Yeah.
Great time.
Yeah.